and welcome to the Immigration Podcast. My name is Rob Ratliff. I'm an immigration attorney in the sunny Cleveland, Ohio. Today we have to put the blinds down because it's sunny, and a former immigration judge. And with me today is my very good friend.
Hi, I'm Gary Martin, and I also do immigration, but on a different side. I'm with the Department of Homeland Security, so I am
And Gary is here
somewhat
in his
from
personal
Indianapolis.
capacity. He is
Yeah.
not
Oh,
representing
yes.
DHS in this podcast. His opinions are his own, and every other disclaimer we can think of. It's just a couple of guys having a chat about the state of the immigration business. So,
Thank you for
yeah.
that, Rob. Yeah.
So, and you're over in Indianapolis, which is a fairly new court, right? How's that going? I mean, facilities wise, everything working, lights come on, all that sort of stuff.
It is. It's yeah. We've been doing pretty well. We haven't had a whole lot of issues. I don't think facility-wise, the parking lot's crumbling. It's a 50-year-old, 52-year-old building, I think, right now. So um, there's some maintenance issues, but knock on wood, most of the elevators still work. Um,
Yeah.
yeah, we're starting some pretty heavy duty master calendar dockets. I think maybe starting tomorrow if they didn't start already this week. I saw one judge had like 100 some odd, master calendars.
Yeah.
In my experience in Louisville, when you start having several judges with several hundred cases a day, and there's all that up and down in the elevators, we're gonna wear out the old ones. So, keep your fingers crossed for us so we stay in
Yeah.
business.
And I don't know because I've never been to the Indianapolis court. Are you guys doing in person hearings or is it all video?
So interestingly, it had. Let me back up. So we are in person. We're co-located with the court. So we go to court where the judges are. We recently had a judge begin to hear detained cases for some of the people that are detained in Indiana, and I believe that judge is in Sterling, um,
Hmm.
Virginia. So the nature of detained, the individuals are all on video, and so the judge is on video, and I think the attorneys in Virginia are covering that docket. We have a new judge that just started this week here. I don't know if he'll be in person or he'll also be video. So, but primarily we're all in person. But we get help from other areas. So some of our attorneys
Yeah.
call in and are on video, and then of course attorneys from other states and cities and things like that are always welcome to appear on video as well.
77 new judges last week got appointed.
I saw that.
A
I know
lot, a
five.
lot of familiar names on the list.
Yeah, I worked with five of them at least. So
Yeah.
five that I know. So
Well,
happy for
and
them. But I think they're
unbeknownst
all
to
remote,
most,
right?
yeah. Well, and unbeknownst to most people, you and I have friends and others that we know well that have reached some of the highest heights of the EOIR immigration court system.
We do
So,
indeed. So yeah,
yeah.
so it's been interesting for me. I know and have had the privilege of working with some people at the highest of heights in my OPLA organization as well. So it's
Yeah.
been an interesting ride.
And it's it's interesting because of all the people that were let go earlier in this administration. It, I think you got to take an appointment as an immigration judge with a little bit of trepidation. I mean, we've got 2 years left in this administration, and how what's the next administration going to look at the appointments of this administration like? I don't know.
So I don't know. I'm proud of and happy for the people who took the leap.
Oh yeah.
I, I wish them every success. I'm a little more um, nervous or anxious, I think, as a person. Not that they'd have me as a judge anyway, but um,
Yeah.
yeah, I don't know that it would be for me right now. And it had been political, and you and I had talked about that like years ago or something like that. So there had been some dismissals early on, terminations early on in Joe Biden's administration as well. The
Yeah.
people who were still in probation under, had been hired under Trump in his first term, and were still on probation, they were let go kind of summarily, I think, when Biden took office, and then it's happened again. And um, I don't know why it wouldn't happen if the if the party, who gets the presidency or which gets the presidency changes again. So I don't know, but
It's one of the interesting things. This administration's taking a lot of heat for some of the things it's doing with the mandatory detention and things like that. But you and I have both been doing this for a long time, and we've seen some of these patterns, and we've seen some of the same types of things in the major changes and the major policy shifts. We've seen that all before. It just seems like now the current administration is doing those things, but times 100. It just seems to be much more, a lot faster, a lot more aggressive, and all those things.
I wonder. I don't know. I'm not a metrics guy, so I don't know, and I'm always kind of skeptical of some of the things that I read in the media, but I don't know. It doesn't feel like big changes where I am.
Mm-hmm.
I was hired under Obama, and it didn't feel like a big change when we went, with Trump in his first term, and didn't feel like a big change with Joe Biden initially, but um, with the secretary that he picked and the head of our office that he picked, um, there was kind of a big pendulum swing under the last one,
Yeah.
and with the issue at the border. I suspected that the pendulum would swing back. But and it appears that it has, but I don't know that it was like if unsophisticated me could predict that. I don't know that it was not expected by, I think, some of the people who are in the think tanks. So
Well, yeah, I don't. I was surprised by how, um, I guess maybe effective is the right word. How I expected there to be significant changes, obviously, from Biden administration policies to this administration policies. But I was a bit surprised at how, one, how quickly they implemented a lot of those policies, and two, how um, effective they've been at enforcing some of those policies. I mean, the first Trump administration, the it seemed to be a lot more haphazard. Like nobody really understood exactly the operations of the courts and the system and all that, and they seem to have studied
yeah.
over the years.
So I don't recall. This is terrible of me, but I don't recall when he ran. Um, and for 2016, I don't recall that immigration was one of his campaign promises or objectives. Um, but
Just
it was
build the wall. That was it.
yeah, but it was certainly when he ran this time. Immigration was um, is a promise that he ran on. So I agree with you. It happened kind of fast, but I think it was like the wheels were probably put in motion during the, I'm guessing,
Yeah.
I don't know, but like during the campaign, if we take the White House, then this is our plan because this is what we kind of promised. So,
Yeah. The one thing I have seen that, especially in court, in the removal defense part of this of immigration, is BIA. We're seeing a lot of BIA opinions, published decisions. I mean, to the extent with your week, those are those have major impact. Those limit immigration judges as to what kind of decisions they can make, what types of rulings they can make, the burdens of proof that are necessary, the showings that have to be made for different types of relief. But those are coming pretty quick. I mean, there was another one just today that I haven't even had a chance to read all the way through.
I think
But
this
how
is
are yeah, exactly. So how are you keeping up with all that? I mean, with you're in court more than most immigration attorneys because you're there all day. I mean, that's what you do. So
yeah.
how are you keeping up with all all those decisions and those changes?
So, and you're probably on it too. We get there's various ways to be notified of when those decisions actually are published. So I get noticed fairly quickly after they're published. It's emailed. The decisions are emailed to me, but I also keep an eye on the EOIR's public facing kind of website has volume 29 of all their decisions, and you check it with that. You can watch them that way, and sometimes I catch them before the emails come out. So. There's a lot of issues, that they're ruling on, and obviously they've all gotten to the board on somebody's appeal. So, but a lot of them don't affect kind of our day to day. Like most, I think of what I do is our asylums and cancellations and adjustments, and some of those are a little more. I don't want to call them obscure because they do affect a lot of people, but for what I do, kind of not my meat and potatoes. But I've taken to reading them, when they come out. Can't commit everything to memory, but you can commit the idea or the issues. I've actually liked it. I don't know how you feel about it. You've been on both sides. Well, you've been on the judge side and then on this side, but I think to the extent that the board can lend some, guidelines or something, that people can know what the rules are, so to speak, or what the burdens are. I don't know. Instead of like, if you go to California, you get a completely different result, or New York, you get a completely different result than you might get in Texas or something like that. There's still always going to be those variations based on the district court law.
And that's, I agree with you. I mean, I want to know what the rules are, and I want to know what the standards are, and and to be able to, present a case according to those standards. But in this sum, I don't think probably a lot of people understand about DHS attorneys in your office there, and all of the DHS offices. Outside my door, I have some law clerks. I have some first and second year associates. I have my personal assistant. There's other staff. There's other attorneys. So when those decisions come out, I have people that can help. It's pretty much Gary, right?
Yeah. So, well, we have each other in the office. We have each other, and we try to make sure that one another know about when the decisions come out, and then, but also if the decisions are impactful, we'll get guidance from our leadership that tells us how this might affect what we're doing. You're, I'm sure, aware of there's always like a district court in California who's trying to set rules for the whole country, and whether or not we're bound by those. You don't want to leave that decision to Gary. You want somebody smarter than Gary to tell me if we are or are not bound by them. So,
well, and that was in my time as a judge. I mean, that was one of the things that two things surprised me. The two things that surprised me most about it was, one, the technology that we had, because it was early in COVID and things were going online. The technology worked really good, and it's even better now. All the WebEx and the judicial tools and everything worked really well. So that shocked me that the government's technology was working so well. But then the second thing was just the lack of support staff. I mean, people may think it's government and the budgets are bloated, but the DHS attorneys, I mean, it was them. There was no. They may have shared a clerk or two, an entry level position or something, but and the judges. I was in Sal and Gina. You were there as well for a time, but each judge had a courtroom assistant, but between us, as far as law clerks, there was 2 law clerks between 5 judges, and one of those law clerks was on assignment to DC, so we didn't really have her. So, I mean, you writing all your own opinions, doing your own orders, all that stuff was commonplace. And I know you, on your end, you're writing your own briefs, you're doing your own motions and motion responses and all that sort of stuff. There's not bloated support staff in either
No,
agency.
I think, and you would know better, but I think like from my friends, some of whom we have in common, ADOIR, when DOJ gets its budget for EOIR, they, they want judges deciding cases, and so that's where the priority goes, is kind of to, let's get judges in here making decisions, and not, they may not be so worried about like making sure the judges have all the staff they need, to act like a judge as we think of judges. But and I don't know, like um, we just got a budget that passed or something like that, so we'll wait and see. But I think we're supposed to get some support staff here in Indianapolis, but we have been going since I think January of 25 without much in the way of support staff. Um, so I've been in interviews before when we're interviewing for department attorneys, and we'll ask the question like, how do you feel about making your own copies, and how do you feel about scanning your own documents? How do you feel about pulling your own files and doing your own research? And
Yeah.
you might not like it, Rob, if you're used to having help. I don't know. So it'd be a
Well,
step back, for you to.
yeah, but and it's different. I mean, I, I, for most of my career before going to the bench, I was a solo attorney or in a smaller firm, and so I did those things anyways.
Yeah.
Um, uh, so that wasn't too much of a change for me, but I can see, um, if you're coming from a bigger firm or U.S. Attorney's Office, maybe,
Yeah.
it's a big difference. But you're going to need the support staff. You mentioned it earlier. You guys are going to these big master calendar dockets.
So that's going to be interesting. Yeah, I don't know. It's funny. They have names for them. They're describing them as large master calendar dockets, but I mean, maybe your experience in Gina was similar. I like 100 case a day docket wasn't unheard of for me. Like we do 50 in the morning or something. 50, maybe bonds and masters counting as two or something like that. But it wasn't unusual to hit 100, I don't think. And when I was in Louisville in whatever 2018, I think the most my friend handled there. I had a colleague there that handled it. I think it was 137 in a day or something like that. So
Yeah.
but then those aren't all like individual. I mean, they're all individual people, but they're not all individual cases, because there'll be family units of 2 and 4, 3 and 4, whatever. So
Yeah.
the
And
necessity for the judge to address
yeah,
137
and
not it.
if you have if if you have a little bit of time, you can kind of sort them into groups to to handle them a little bit more efficiently. But when what years were you at Gina?
So I was actually part of the group that opened Gina in 2017,
Okay.
um, and then we had visiting judges that came through, and we had visiting ACCs, as we were called back then, who would come also on detail, to service the
Yeah.
courts with the visiting judges. But I was already in Louisiana. I was in Oakdale, and so we were able to go to Gina and also help. And I had a
So,
colleague there who was there.
so you were in Oakdale during the Obama administration then.
Yes. Yeah.
So the deportation rates during the Obama administration were fairly high too. Maybe not quite as high as right now, but the detention rates were high at that time as well. In Oakdale, and Oakdale was crowded. I mean, how big of dockets were you guys doing then?
So those were the dockets. Well, at least when Gina opened, I remember dockets being, you know, 50 to 70 or something like that.
Yeah.
Unless my memory's not great, but I remember like the judges talking about like having had 100 case docket the day before. But, that'd be 50 cases, like, and each one would have a master and a bond or something like that. So
Yeah.
but those are two separate hearings, obviously.
But at that time, I would come to Oakdale every once in a while, but I mean, it kind of in and out with one or two cases. But going to Atlanta at that time, I mean, on master calendar days, I mean, the lines would be out in the hallways.
Yeah.
I mean, you'd get there for cases with judges would start hearing cases at 8 in the morning, and you may still be standing in the hallway waiting on your case to be called at 1 or 2 o'clock in the afternoon. So those, the 2 or 3 pages of cases weren't that unusual at that period of time. I don't think. And then in my time in LaSalle, yeah, 50-ish wasn't unheard of on a daily basis for masters.
Were you doing though masters and bonds in the morning and then merits in the afternoon, or?
Sometimes that was mostly the way it was set up. I was pleasantly surprised back then at how much control we had over kind of structuring our dockets and trying to keep certain types of cases on certain days. But even with that many masters, it wasn't always initial masters, because you had call ups and other things that maybe 2 or 3 minutes on the record and ready to go. So,
Yeah, there's an efficiency, to those detained dockets.
yeah, but I did, and only for I think like 2 weeks, but I did an assignment because one of the judges at El Paso was out, and when they were still doing the MPP cases, the Remain in Mexico cases.
Yeah.
And the process there was you would get a date. You had to stay in Mexico, but then you would get a date that you could come across the border, and you would show up for your master calendar hearing. Those were all by video, and I there was 300 and some one day, and
that's pretty amazing.
Yeah, I mean there were massive numbers of people. Kind
Where
of
would they put them?
they showed up, and I don't know what the facility was. It was some sort of a border facility, and it was a giant conference room.
Okay.
And I mean it was like a conference meeting. There's no tables, but just chairs, rows and rows of chairs, and you kind of doing it by raising your hand, going through the advisals. Who is anybody here a citizen? Does anybody believe?
Yeah.
And raise your hand. Do you have a fear of returning back to Mexico? Raise your hand. And it you got through them. I mean, it's doable. I mean, it's not ideal, but
No, it's born of necessity, or whatever. So it's kind of those numbers are. Everybody's entitled to their day, and we're trying to get however many million of them through. So it's balancing act.
Yeah, you know what? And that reminds me of something I wanted to ask you about was I'd read, it's been maybe a month ago now, where they eliminated I don't know if they were volunteers or if they were paid, but they eliminated the people that were working in the detention facilities that were providing some advice and assistance with some of the forms and things. I know you don't do a bunch of detained cases now, but have you seen much impact from that?
So I'm still doing detained here.
Okay.
I don't. I may not be doing it for longer. I don't know. So we still have two judges here that do detained, and now the one that's in Virginia that's doing detained. And then we've added a judge this week who I think is going to take over for one. I don't know. We'll see how that works out. But so I'm familiar, that we used to have like Catholic Charities or something like, another NGO that would go in and give an orientation. They would call it, I think. And I honestly, I don't know. I guess I wasn't aware that they had stopped doing that, or if they had stopped doing that, or maybe they just stopped funding it. Is that what happened, or do they not let them in anymore? Or?
And I don't know. I think it's that they're just not letting them in, and they're definitely not funding it. Um, and the issue is, and I don't know if people understand it, someone not involved in the immigration system understand it, but no matter where you're from in the world, when you're detained, all the immigration forms are in English. And uh, whether you have an attorney or not, you're responsible for filling out your form. You're responsible for submitting it to the court, and you're responsible for presenting your case to the court. Now, you get an interpreter for your hearing, and if the judge or the prosecutor or even your attorney is asking you questions, there's an interpreter for that. But to actually file your form in English, you're on your own. And so, there may be someone from your country or speaks your language that's able to help you that's also detained, but people are on their own, and it doesn't matter um, what your educational background is, what your literacy level is. There were some countries where literacy levels were much lower than average, and in some places where the language was very rare.
Yes.
So so those individuals have to complete that form. Now, I don't think that those services and those organizations that were in the facilities were necessarily helping them fill out the forms or translating, but I think maybe at least helping them know which form is which. Is
Right.
this cancellation? Is this the asylum? Which one do I fill out? So
So
that was an unusual thing.
what we've done, what I've seen done here, um, we'll send the forms, to anyone who's in a master calendar or anyone who claims a fear of returning home. Um, we'll provide them with an I-589. I believe you would know better, but I think it's the court's responsibility usually to get it to them. But because of how we're operating here, it's just easier for me to, you know, I email the detention center, and they print it and give it to the person. And then there is a law library or a library that they use. And then it is not. I have not had a case in my time with OPLA where someone has not been able to find help, submitting a claim in English. So sometimes they use that Google Translate, but almost everyone that I've encountered in court, and I don't speak for across the country or anything like that, just the people that I've encountered, they have family or friends, or there's somebody here who was here to receive them when they got to the
Yeah.
United States. So, and they'll have help filling out applications, and then, you know, they may not be perfectly filled out. So, but then, when you get to the merits hearing and you have the interpreter, they're entitled to tell their whole story, and we hopefully develop the record that way, what happened to them or what they fear, or, why they came to the United States or whatever.
Yeah.
I don't know. I don't know how it is in Cleveland. Again, I wasn't aware that we had that those places weren't allowed
It's
in places.
yeah, it's an interesting conflict, I think, right now, and I don't know what the long-term ramifications of it are going to be and what the litigation is going to be, but we're seeing there's even a fairly recent BIA decision that basically said the judges have a duty to, elicit
Off the record.
elicit the information from the respondents. There's a Fourth Circuit decision from maybe a month ago now that basically said judges have a duty to get the information out, but then the policy memos that kind of directed the judges to pre-termit cases where the applications are incomplete or don't state a valid claim. There's almost a bit of a conflict there. Like I don't know, can you pre-termit if the person hasn't had a chance to come into court and say, hey, this is why I need this form of relief? I
That's good. Yeah, I don't know. I'd have to think about what I've experienced. the case that allows or talked about pretermission for an incomplete application.
Mm-hmm.
If I remember correctly, the facts in that were that the applicant had been given another opportunity or given an opportunity, was told of the deficiency and given an opportunity to fix it and didn't. But I don't know.
Yeah.
But in practice, how that case is applied in the cases that I've been in, or the courts that I've been in here, that's also the case. Like they'll be given 30 days or something like that to file a complete application. And also, because that case came out, when did CAR come out? Was it this year or last? I don't know. These all run together, but recently, right? So
yeah, last few months.
Let's say we have an individual on the non-detained, and for those of your viewers that don't know, when Indianapolis opened a court, a lot of the people who had cases pending, their cases were pending in the Chicago court if they lived in Indiana, because that was the closest court. So their cases were moved here to Indianapolis, so now it's closer for them. And if their I-589s were incomplete but accepted by a judge without objection in Chicago, I've not seen judges here pretermit those for being incomplete. It's almost like a waiver or whatever, I don't know. But so what I think how that case is being applied here, at least, is if someone submits an incomplete application, they're told it's incomplete and given time to complete it. And if someone has completed an application and now we find ourselves at the merits hearing, years later, and they've not been given notice that their application's incomplete, we just talk to them about their, whatever their fear was or whatever. Like, I don't think a judge is going to, not here. Again, I don't know what happens around the country, but not here. They wouldn't pretermit for that. So.
Well, and that's one of the things I've cautioned a lot of clients and even not clients, people that have come in for consultations or whatever, and their next court hearing may be 2 years down the road, but they've got clearly an inadequate asylum application or something filed and pending, and maybe it wasn't inadequate at the time, but maybe it's inadequate now because they didn't go through the third party country transit stuff, or some of the other issues that are there now, or doesn't state a good PSG or whatever it is. And I've told them, I said, look, you don't want to sit back and wait. You don't want to sit back and wait on that next court date thinking that nothing's going to happen. Eventually, the AI bots are going to scour through the EOIR database and pick out all the bad cases and put one on the top. I'm convinced that that's going to happen. I don't know if it will or not. But
that may. That's I mean, AI is amazing. I don't understand it. It makes for interesting memes on social media. I know that. But I can envision, and I can't think of examples, but I'm pretty sure there are some. Where also it used to be. It's interesting, right? You and I kind of last time we did one of these together, we were talking about mandatory custody and how maybe it wasn't the department's interpretation of the act wasn't always interpreted, like it didn't always interpret it that way or whatever. So, and but I thought after that I was kind of thinking about our conversation, and we had that Pereira decision, whatever, back in 2018. Someone said, hey, if a date and time is not on the NTA for the initial master calendar, it's not a good NTA, and that's what we did for 30 years or whatever. So it's never too late to say, it doesn't matter if we've been doing it one way for 20 years or something like that. If it's not the right way, there's never a bad time to fix it and go forward. I don't know how the courts are ultimately going to rule on the detention thing, but we had just been talking about, like, how latches don't attach to the king or whatever, affect the king. So, but on this one, I distinctly remember seeing I-589s that are filled out usually with counsel, and these are probably several years ago, where they would say, I will supplement.
Mm-hmm.
I'll tell my story later. I'll do a declaration later.
Yeah.
So it wouldn't even really be attached. Like I think in matter of car, there was an application or there was a declaration attached, and the board said, that's not good enough because you got to fill it out on the form or whatever. But I do know they're almost like placeholder, NTAs. Like we'll file it, we'll get you in before the deadline, perhaps, and but still not give the court or the department any clue, like what your claim is. We'll just supplement it before the called up date for the merits hearing. So I don't know. So it's kind of an example of what we were talking about earlier. I kind of like the guidance from the board. Yeah. Now we all know what the rules are. We can start following the rules. And again, I've not seen that rule kind of applied, in a way that harms respondents, and not here in this court. Like there's not a judge that's going to do that without giving them an opportunity, I don't think, to complete their, to complete the form. Or if it's not for merits and everyone's there and the interpreter's there, then let's just go forward and find out, what.
Yeah, get the details. It's really interesting, the analogy between the no date, no time NTAs and the mandatory detention. I mean, those are I've seen orders to show cause that are 30 years old that don't have date and times on them.
It's interesting you say. I'm briefing one right now with my lack of legal assistance. A guy who's a guy or girl, I don't know, but I have an order to show cause that's 36 years old.
With no date, no time.
No date, no time. And so the Seventh Circuit, where I sit, has looked at that and said, the rule that requires the date and time came in 91 or whatever. And, my order to show cause predates that, so it wasn't required by any rule. And so we'll see how it, we'll see how it bears out. But in my particular case, I don't know. But it's interesting because presented with the issue, and I'm like, man, I think maybe I've seen 3 orders to show cause in my 10 or 11 years or whatever. They're not, you don't see them kicking around too often.
They used to see a lot of them way back when, but when they went to NTAs in 96, I guess 96, 97.
I thought it was 96, but there's a 91 date in the I'm still not to the bottom of it, in the cases that I'm reading. So or the regulations may have changed it, right? Maybe in 90.
Yeah, I don't remember. I don't remember when it changed.
The IRA, yeah, I would thought it had changed then, but I don't know when they started issuing NTAs. If that was 91 or if that was post IRA.
All right. Well, it's about time to wrap it up, but I got one last question for you, Gary. I'm the next book in our Pro Se Immigration Law Library series is going to be about waivers. So waivers in court and now waivers at consulate, because everybody's going to have to leave to come back. What's your favorite waiver?
So I don't know. That's a good question. So I was thinking today, actually, that if I was asked that or something similar by you, I'm not a fan of the fraud waivers. I don't know why we forgive that kind of stuff, I guess. But I think that'd be harder on people who committed fraud, either to get in or to adjust. But so that's probably my least favorite waiver. And that's the the one that covers, I guess, the most. That's a good question. I don't know if I have any.
But that's interesting. I hadn't really thought about it. I was thinking, my favorite waiver was one that it has went away, and that was the 212C, which allowed people with certain convictions, if they met other standards, to get a waiver to maintain their green card. And I think that played a very important role for a long time. And I got to tell you, I think I'd rather have that waiver back than some, if I had to give up one to get that back, the fraud waiver, there's small fraud where it's inadvertent, didn't disclose something like that. But there's also that intentional fraud that sometimes just, makes you cringe a little bit that's waivable, but some kid with a 10-year-old, personal use amount of a little bit of cocaine residue in a bottle in these pants is gone forever, and there's
Right.
no coming back from that.
I think
So,
I had a case not long ago, maybe this year, where the potential for a 212C was was there. It depends on when their conviction was, right before,
yeah,
whether that waiver would have been available to them before the change in the law. So
yeah.
when their
It,
adjustment was and where it was, whether it was in or out, or is that part of 212C? In my case, I didn't. It wasn't applicable.
yeah, and there was all, and a lot of people don't remember, but there was a lot of people that got deported between 97 and '01, whatever it was, when that St. Cyr decision came out, that didn't find their way back because they got deported faster than the Supreme Court could say you couldn't do it retroactively. So, you know, and we're seeing it now, and the reason it comes up is we have a lot of people that came as refugees in the 80s and 90s from Southeast Asia, Vietnam, Laos, Cambodia, and I don't know what the percentage is, but it's a high percentage of young boys and men at that time that basically came from a war, spent some time in a refugee camp, and then just get plopped down in the United States with no nothing. Here you are, welcome.
Yeah.
And so many of them got in trouble. So many of them, something happened, and now they have those old removal orders 30 years ago, but now they're all getting detained.
Yeah.
And you're not seeing it because we see it on our side because we're filing habeas actions, and we're going into federal court to enforce old release orders and things like that. But it's just one mistake, and for many of them, it was something fairly minor, at that time in the 90s, a little bit of ecstasy, or maybe, maybe.
I was in Louisiana in Oakdale when Huma was an issue, and it sounds very similar. These were people brought back into detention after convictions are, I don't know, 20 years old or something like that.
Yeah.
Removal orders that are that old, I guess.
Yeah.
And and then it used to be, I'm sure you remember, I think with Cubans, even when I started, they were anxious to get removal orders if they were detained. So, and they would take a removal order or waive appeal because they knew we weren't going to be able to remove them. So,
yeah,
so they waited their 90 days and be released, and then once we were able to remove them again, they probably regretted that decision. So,
well, we could probably do a whole show on just issues with the Cuban cases now, just on what's parole, what's not parole, what's adjustment eligible, what's not adjustment eligible. It's very confusing. So for everybody,
that might be a fascinating one. Are you brushing off your mandamus skills, or are you thinking about that with any of these adjustment issues that are?
I am, and it's interesting, and I don't think there is any pattern to what Cuban national may have got the qualifying type of parole, got the unqualifying type of parole that now probably qualifies, which ones got detained and then later bonded out, which ones were just ROR'd at the border. It doesn't seem like there was. It just seems like whatever, random.
Might have depended, and I don't know, but it might have depended on where they were encountered, how
busy it was that day.
How busy the Border Patrol agent or agencies or agents were. I don't know. They're all detained at different times and probably maybe different locations, and whether they're arriving aliens, and applied for admission, and then I don't know. It's all fascinating stuff. So
Yeah, unless you're the person detained. It's fascinating for us, but if you're detained or
No, I agree. So
yeah, getting on a government
that's not
plane in
much.
shackles, that changes it a little bit.
But if you're here, and I don't know, I'm just playing devil's advocate. I mean, if you're here and you feel you have a meritorious, you know, application or means to remain here, and being detained for a few weeks is certainly unpleasant. I wouldn't recommend it to anybody, but you'll get an answer faster than I don't know what it would be like to live in uncertainty for like years and years on a detained site, and go through administration change after administration change and stuff like that. I mean,
yeah, the stress of going through the process for 5, 10, 15 years, I can't imagine. But the stress of being, killed in your home country is probably pretty high as well. So
yeah.
Gary, good to see you.
It's good to see you, my friend. Thank you for having me, and it's been
Oh, not a problem. Tell our mutual friend in Indianapolis I said hello, and
I will. So
yeah.
So I appreciate you, Rob, and I look forward to our next one.
Yeah. And